Sir, it's 11:10, so shall we start the program, sir? 40 plus.
Yes. You can start.
I think we can start.
Sure. Good morning, ladies and gentlemen. Respected Honorary Director General of ADCOG, Mr. Uday Bhaskar, President Dr. Jayanta Chowdhury, distinguished guest for today's webinar, Shri S.R. Salunke ji, and all the colleagues from State and Central Drug Regulatory Department and friends from the industry and academia. Very good morning, everyone, and I take the pleasure to invite you all for the 25th webinar of All India Drugs Control Officers Confederation Training Academy webinar on Right to Information Act 2005, Public Authority and Regulators Perspective and Implementation Aspects. We are so privileged to have with us an expert in the RTI Act, our former colleague, Shri Shalunke ji, with us today. And now I would like to invite our Honorary Director General, Mr. Uday Bhaskar ji, for the introductory remarks.
Thank you, Lakshmi. Good morning, everyone. My good friend and the past Vice President of All India Drugs Control Officers Confederation and activist in the All India Drugs Control Officers Confederation, as well as Drugs Inspectors Welfare Association of Maharashtra, who is always, smiling. People love to spend time with him. At the outset, I'm very much thankful to R.P. Chowdhury for introducing Salunke, that Salunke is equally good in RTI Act. I was not knowing that. All these days I was thinking that most of the regulators, they are good in Drugs Act, DMR, DPCO, but I was a little bit surprised. Even I worked in drugs control and almost completed 34 years of service. Still, I have so many doubts on Right to Information Act. The reason is that as a regulator, I always think if anybody asks you some information, you will get irritated. Our mindset, we always ask the people to give the information. So it's the first instance itself, we have some sort of an allergy to give the information. That is one thing. The second thing is that it's also my experience. Most of the information sought by the activists of RTI, they always ask the information which they want, and most of them are not taking the information for the correct purpose. But fortunately or unfortunately, you have to give the information whoever asks. Even after, of course, it is almost 17th, this is the 17th year RTI Act introduced in India. Right to information is always a right. Sometimes our officers also taking the information under RTI Act. Even one of the drug control officers in Telangana, when DG is not giving the information, they filed application under RTI. So this, the people always feel the people at the higher ups, whoever heading that office, that is the property. So they don't like to give that information for the reasons better known to them. The reason is that very recently, there are so many things. And with this confusion, RTI activists, whatever information is available, we're supposed to do. Anyhow, Salunke is going to talk. But sometimes they will ask us to get the information, collect the information and give it to them. These are all confusions. And I think most of the participants certainly will have a value addition to their knowledge as far as RTI Act is concerned. We also have our President Jayanta Chaudhary. I'm once again very much thankful to Salunke for accepting this invite, and I think people like me also learn so much from these discussions. Thank you, Lakshmi, and thank you very much.
Thank you so much, sir. As already mentioned by Uday Bhaskarji, Salunke ji has served for the drug inspectors or the regulators association of the country, both on ADCOC level and on even at the state level of the Drugs Inspectors Welfare Association and other part. So all in all, Salunke ji is having 27 years of vibrant experience in the pharmaceutical profession. Not only in the regulatory department, but he also had an experience of serving the industry before prior to joining the department of FDA Maharashtra. So he was the former assistant commissioner of drugs at Food and Drug Administration Maharashtra, and currently he is the practicing pharma auditor and consultant, and offering the techno-legal services, advices to the pharma industry, cosmetics, and all other related industries. So he is a freelancer on investigations, audits, training and skill development, and so many officers of our colleagues from the state drug control departments and CDSO had got the opportunity of getting training under him on different subjects, and also the industry and trade chemists and pharmacists, and especially his expertise on the Right to Information Act and protection of privacy and confidentiality of commercial trade secrets is best known among the pharma community in the country. So he is a speaker on the global drug regulations and RTI and administration, as mentioned. And on behalf, and as a freelancer auditor, he is serving on behalf of a US-based renowned company for vendor qualifications for the Indian companies who are applying for the US FDA and EU regulations. So we are so privileged to have you with us, sir. And I must fail in my duty if I don't mention the awards that Salunke ji was conferred for the best services he has offered to the regulators and the industry and the pharma community in the country. And he was honored with several awards, to name a few: the Gaurav Puraskar by the state government of Maharashtra for the excellent and remarkable services as a drug regulator. And he also conferred with Uttam Karyakarta and MPA award, and several such awards by the different organizations for the services that he has offered, not to the pharma industry, but also to the general society. So we are so privileged and pleased to have you with us, sir, and we look forward to learn lots of insights on the RTI Act. Over to you, sir.
Hello. Thank you, Lakshmi ji and Uday ji, for good words. So, shall I start?
Yes, sir, please.
Yeah. So, presentation is visible, no? Clearly?
Yes, sir. It's very clear, sir.
Yeah, yeah. Screen open. Okay, today, good morning, all of you, dear regulators and the public authority persons and some industry personnel. It's a pleasure to me associated with you all on this occasion, and I thanks Lakshmi ji and Uday Bhaskar ji for giving me opportunity to interact with you all on this issue. Right to Information Act, public authority regulators perspective, implementation aspect. The agenda for today is freedom of information, right to information, international and India perspective, Right to Information Act 2005, various provisions, role, power and authority of public information officer, first appellate authority, information commission and public authority, rights of Indian citizen. Another question is always, can other country citizen ask the information from the public authority of India, mandatory and voluntary publications, penalty to PIO, deemed PIO, and the first appellate authority. What is meant by third party and their rights, and different landmark judgment of the Supreme Court, High Court, and Information Commission. As we are implementing the law since last 17 years, so provisions are there, everybody is implementing it. So I will spend maximum time on the landmark judgments and the different queries. Since last 15 years, I am receiving, and based on the so many judgments I have gone through, especially High Court, Supreme Court judgments, and even the in Central Information Commission, especially full bench judgments. So that is a concluding our we can say the landmark, and thereafter at the end we will have a question answer session. Before starting presentation, I feel very proud, spiritually, socially, and even lawfully, that I am a son of India. I am a citizen of India. Our Constitution, Article 19(1), gave me and all of us the freedom of information, freedom of speech, and freedom of expression. And since 2005, freedom of information, freedom of right to information. The movement of freedom of information started long back. The Gandhiji said, real Swaraj, real democracy will come not by the acquisition of the authority by few, but the acquisition of the capacity by all to resist the authority when it is abused. The democracy must be extended beyond the ballot box, and it must be deepened through social citizenship and citizen governance. So it is not necessarily that we elect the persons, or we, as far as the political leaders are concerned, as well as the government employee, once they are appointed, they are whole and soul. It is not the democracy. It cannot be a democracy. This is the theme expressed by our great leader, Mahatma Gandhi. The Right to Information Act is not limited to our India. Even in the United and as a General Assembly's resolution, there are different resolutions since 1946 to 2003. Freedom of information and freedom of expression is a fundamental human right. Public body hold the information. Ravi Bhaskarji just now very categorically expressed that we are the custodian of the information, and we should publish that information. Simplify administrative procedures, participation of society in the governance, no tolerance to corruption, and most important, because after giving so much authority, even a United Nations observed that there is a need of protection of the privacy of the personal data. So this is the international scenario. So these are the so many countries. We sometimes, some officers feel that what law India had brought into picture, but this is not the case. Everywhere in the world, so many countries are enacted the Freedom of Information Act or Right to Information Acts. These are some examples. So India, as per the constitutional backbone to the RTI, Article 19(1) give us a freedom of speech and freedom of expression. There are a lot of debate on this issue in 1973-75 that freedom of expression and freedom of speech doesn't covers the freedom of getting information from the government offices. Even when I joined 90s in the department, if some visitor touched the even government files or opened the files, officer used to shout on them that how you are dare to touch the file, because this is a government document, secret document, but this is not the case. We are the custodian of the public document. That is a public document. So these judgments are in Government of India versus Cricket Association, Bennett and Coleman, and the Rajnarayan case, very famous case of 75-73 era, freedom of speech and expression bestowed upon us under Article 19(1) give us to acquire the information and to disseminate it or publish it. People of the country have very much right to know every public act of their public functionary. This was in 1973. The movement of the RTI in India, actual for enactment, there was the Mazdoor Kisan Shakti Sangathan Rajasthan. Here, what was happened? The Mukadam of or that leader of that group used to take the sign on a blank paper and write some salary and give something different salary. The Mazdoor asked that we want that salary slip, but he denied this is a government document. Then that time this agitation started. Lok Satta in NGO AP, there was a postcard campaign. In 1997, Shourie Committee drafted a first bill, Freedom of Information Bill. In 1970-91 CM conference, this issue was discussed at length, and in 2000 the act was enacted through the via bill, but it is not notified, so not implemented. Same is the case of the 2002 act. And in 2004 there was a lot of discussion on the National Advisory Council, and in 2005 we got the great act, Right to Information Act. Right to Information Act is published on 21st June 2005. Generally, in every act, as far as other act is concerned, effective date is the same. But here in this act, very nicely drafted act, effective dates are given a different date. For initial 100 days was given under section 4, 5, 12, 13, 14, all these are on screen. That was for preparatory period. The government officials were said that you prepare for this act. We are already brought in the picture the Right to Information Act. It includes the appointment of the PIO, First Appellate Authority, commissions, and all other formality. Catalog your documents, index your documents. Maximally, you convert that document into the electronic format. And with effect from 12 October 2005, this act is available to all the citizens. It extends to the whole of India. Earlier it was except to J&K, but with effect from 31st October 2019, it is applicable to whole of India. So overview is the Right to Information, though it is a very small act, only 31 sections, 6 chapter. This act have a substantial substantive provision as well as the procedural provisions. We see the other, in case of the other act, the CRPC, you have to refer CRPC or Civil Procedure Code. But here, this is a very nicely drafted act. Both provisions are there. What procedure you have to follow and what is the substantive or legal requirement. So chapter 1 deals with the title and definition. Chapter 2 deals with the obligation of the public authority. Then chapter 3 and 4, Central and State Information Commission. I will not much speak on this because this is their concern with the appointment, then salaries, and then removal of the information commissioner, and which is not much useful to our officers. And I would like to spend more time on the other, which is useful for our regulators. Then chapter 5 is a power function of the Information Commission, appeal and penalties. And chapter 6 is a miscellaneous. There are 2 schedules. Is the oath of, first schedule is oath of the CIC and SIC, and another is second schedule is the list of organization to whom act is not applicable. Earlier it was 18 organizations which are exempted from the RTI. Now there it's 22. So preamble and objective of the act: to promote transparency, contain corruption, accountability of the public authority, access to information is the basic theme of the act. Responsible public authority and informed citizens. Act is a practical regime, harmonizes conflict of interest. This is in the because the regulators were knowing. Even United Nations, you observe that there must be conflict of interest. As very rightly pointed out by Udayji, there are many citizens who misuse this act. So this act it's a practical regime which harmonizes the conflict of interest, the efficient operation of the government, optimum use of limited fiscal resources, preservation of confidentiality of sensitive information of the state as well as the person. Important definition, I have not covered all the definition because there are routine definitions, but competent authority, this is very much important, and many officers get confused between these. They say that government is everything. Here, as far as this act is concerned, competent authority is a speaker of the legislative assembly in the central as well as the state, chief justice of the Supreme Court, High Court, president and governors and administrator of the some state. So these are the competent authorities. So whenever the law, anywhere in the law, competent authority permission is required, you have to refer this, or the RTI activist has to refer this. Then information, what is mean by information means any material in any form, including records, document, memo, email, opinions, advice, press release, circulars, orders, logbooks, contract, report, papers, samples, model data, materials held in electronic form also, information relating to any private body which can be accessed by public authority under the other law for the time being course. If you see the definition of the information, it covers everything in the office, what is available in the office. As soon as you enter in the office, everything is under the right definition of information. If you have a big library, it is also comes under the definition of information. This definition is many times misinterpreted by the activist. I'm coming to next, how it is misinterpreted. Public authority. What is meant by public authority is any authority, any body or institution of self-government established or constituted by or under constitution, parliament or state law, appropriate government, including body owned, controlled or substantially financed by the government. So all government offices are a public authority. Public authority word is used. Government offices word is very rarely used here, but public authority word is used. Even NGO substantially financed directly or indirectly by the government. If there is a NGO, they have a separate this thing constitution. But if NGO is substantially financed, there are many colleges. The funds of the or salaries of the colleges are given by the government. So that even by that college is installed or this college is formed by some NGO, that becomes the public authority because it is substantially financed by the government. So NGO should be aware of whether they want to come under ambit of the RTI or not. Then each unit of the government office is a separate public authority. This provision is also misinterpreted by the many activists. What they do, they apply in the head office or in Mantralaya, and they ask that we want this information from all your district and all your subordinate offices. But this is not the case. As far as the public authority definition is concerned, each office or each unit is notified by the different notification, and therefore, though it is a head office is not a public authority with reference to their district office or subunit of that office. So district branch, this is a judgment of Information Commission. District branch is a separate public authority, and if any activist or if any RTA applicant, I will say citizen, prudent citizen, want information, he has to apply in that particular district office and not to the head office. A public authority which does not hold or is not related to any information sought by the petitioner will not be obliged to provide answer to the petitioner only for the reason that the public authority was the apex body or nodal office of the other subordinate public authority. These are the landmark judgment in the Ketan Modi case. This is a full bench judgment of the Central Information Commission, and it is a binding judgment to all. Important definition. We have seen the information, what is meant by information, and this is a right to information. The information is there, everything is there, but you citizen have not a right to ask anything. What they can ask is the right to information means the right to information accessible under this act, which is held by or under the control of a public authority. I will explain what is under control means, under control of public authority, and includes the right to inspection. It covers the inspection also. Any citizen can come for inspection of the office, they can take the notes of that. If you give the inspection, they can take the note, take the extract, take the copies, take certified sample material, obtain the information in the form of disk, copies, or even today's scenario, pen drives. Then what is meant by third party? Third party means any person other than the citizen who is making the application, PIO, all others are third party. Even our office is a third party. And other person, because as a regulator, we receive a lot of information from the industry or the from trade. So they are also third party. Their information is with us annexed to our application. So they are also a third party. So file notings, sometimes some officers say that internal submission is not information. Okay, no, it's not the case. File noting is the opinion of the officer on their case. So file noting is also a information and you are supposed to give it. But subject to section 8 and 9, that is exemption section, information need not be created if not available. Sometimes they say that I am giving this format and the tabular format, you design that format and give information. No, you are not supposed to give. If that format coincidentally is there, definitely give, but information did not be created by the officer, straightway application can be rejected because information asked in your format is not available with this office. So information cannot be given. PIO not to create information, provide in the form exist or if it exists. If it is not exist, not action. VDAD record cannot be provided as it is not exist. But here I request all the offices, government offices, that your VD policy should be very, very strong. It should be documented. It should be approved by the government. Otherwise, there will be a blame on the government official that it is intentionally VDAD. So your policy should be very strong and unnecessary document should be VDAD, but record should be kept that this is a record and this is supported by the your bidding policy. No obligation to answer questions or give opinions. Sometimes some citizen asks the application. Basically, I am of the opinion that it is not necessarily that this act is being used by the only some nuisance creating persons or something. Some people are genuinely innocent. So there is every possibility that what foolish question they are asking, what a ridiculous question they are asking. Question may be ridiculous and but application may be ridiculous, but your answer should not. Answer should be very sober, decent. This is my request to all of officers. So important judgment on this issue is what is meant by controlled under the government office. Information under the control of public authority means, what is meant by means any such information which is held authoritatively and legitimately. For example, we receive many communication from the central government and that is available in our file, or some other from court offices or many offices for that purpose. Then if the application comes to us, can you give as per this law under control means, is it authority, you have authority or legitimate document? There is every possibility that that document might have been amended. So proper office is that office who is a legitimate authority of that document. Then information sought does not relate to the function of the public authority. Sometimes I already said that you have a big library and there are a lot of information available from the worldwide. So is it accessible to citizen under the Right to Information Act? No, because that is not concerned with your office. Though information is there, it may be in your bag also, but that is not concerned with your function. So these are the most important aspect. Citizens are misusing, applicants are misusing, and our regulators are confused that they have asked, they have applied, then that therefore I have to give. You have to say that this is not concerned with the, okay, document is available. They know, sometimes they know that this file is there. In fact, it is on the table of the public information officer. But we can very well decently and soberly say that this is not a legitimate document and I am the not authority of this document and therefore I cannot provide it. you can apply to the right authority. Only when this sentence give us authority, all the citizens shall have a right to information subject to the provision of this act. Only one sentence, all citizens means abroad country or other country personnel cannot take the information. Only Indian citizen can take the information. And another is right to information. So it's not only information. Sometimes some activists bifurcate this word, right to an information, and they say that information means all these things. So this right to information is categorically defined under this act. So all citizens have a right to information subject to the provision of this act. So what is stated in the act, and there are certain exemptions that has to be considered under giving the information. So obligation of the under section 4, there was a 100-day preparatory time given after the enactment. This preparatory time was given to cataloging document, indexing document, computerization of the document, and connecting to the network. Here, most important thing is that some activists again go to the some district or small offices and they say that as per the RTI Act 2005, everything should be on the website and all these things. But government had not provided the fund. How that officer will do it? So here that word is there, subject to availability of resources. So officer should not come under pressure that I have not done it because you have not been given any fund. Therefore, this wording is important. So don't worry. Say even government will not say anything to you. Even if there is a complaint to government or complaint to Information Commission, they cannot say. The right law itself say that subject to availability of the resources. Then further 20 days and total 120 days was given for voluntary publications. Particulars of, and there are 17 mandatory provisions, mandatory clauses. Here, every office is required to prepare one booklet and even to publish on the website these points. And this is a voluntary publications and mandatory publication. Every year it has to be amended. Preferably in the April, we should amend this. And for giving this information, there is no time. As soon as any citizen come to your office, you have to hand over that document to him. No time, 30 days time. What is it? In fact, it is expected that you publish it on the website. Particular of organization, function and duties, power and duties of the officers and employee, decision-making process, norms and discharge of its function, rules for discharging functions, then categories of the document held, arrangement for consultation, policy and implementation, board, council, committee, if there are different committees in the office, that details we have to disclose. Then directory of the officers and employee, their monthly remuneration, budget allocation, subsidy program, then concession, to whom we are giving concession, information held in electronic form, facility available to citizen obtaining information, working hour of the library or reading room, if it is available, if maintained for the public use. Here, this is important. If maintained for the public use, if it is not maintained for the public use, you are not supposed to give access to our library. Particulars of the first public information officer, first appellate authority, and such other authority. Update this information yearly. I have come across last couple of years that officers are not aware of, that they have not even published this document, and this is required to be readily available. And if it is not there, you are liable for action. Then publish information. What are the other obligations? Publish information, important policies and decisions which affect the public. This is the even Right to Information Act. It is our constitutional right also to know the regulations. Therefore, governments draft rules are publishing. But sometimes even some authority, I find, even I have observed that in one case, the decision was signed in the Delhi that this particular drug is banned with effect from today. Today means that decision reaches to the district offices and all this after 15 days. And one officers, commissioner say that from next day you have to prosecute everyone. How it is possible? Is it correct? Therefore, publish each and every information, policies and decision which affect the public. Give reason for administrative and quasi-judicial decision to affected person. Suo motu, widely publish maximum information so that there will not be any ambiguity or difference of the opinion or some communication gap between the citizens and you. Disseminate information in the form and a manner which is accessible to the public. Here in the form, very intentionally I elaborate because in the Grama Panchayat rule, how they will know the electronic format. Therefore, in the Grama Panchayat, they are expected to post the big posters and all these things. So form means that form. Dissemination means local language. It should be in the local language. Consider the cost effectiveness. Here another important officer can take. If the government had not given you a finance, then nobody can say that this is not available. Cost effectiveness is most important. And I request all the officers, they must have done it already. But today just I am again repeating it. Ask the fund for the right to information, implementation of Right to Information Act. Even central government is providing the fund. Then easily available with all information should be easily available with the PIO, available for inspection. Public information officer of that particular day, generally nowadays it is considered as it's a punishment. But in my opinion, public information officer is a very strong person. Each and everything happening in the office should be available with the public PIO, nothing secret to him. So can you imagine what kind of information he is having to the extent possible in electronic format? Dissemination means notice board, then newspaper, public announcement, media broadcast, internet, and all these things. Then section 5 deals with the designation of PIO in all administrative unit. 100 days was given. Designate a PIO. In some central government had appointed the APIO post office as a APIO because it's not possible to a corner of the country cannot go to Delhi and apply. Therefore, the APIO is a post office, and here 5-day extra time is given. If the application is submitted to APIO, then 5-day time is, otherwise 30 days time is there. Only PIO PIO to deal with application. This is again misunderstood provision by the many PIOs or many public authority. Some public PIO very irritatedly say that this particular information is concerned with you. It is your headache. Give to that applicant. My job is over. I have transferred your application, but it is not the case. As per the law, only PIO is to deal with the application, and if it is happen contradictory, then PIO is liable for action. So PIO should take the information from the subordinate or other officers deemed PIO. PIO shall give reasonable assistance to applicant. If any disabled person or illiterate person come to the PIO and I want to do some application, then PIO has to deduce that information and he has to help that person. PIO may seek the assistance of any other officers. Here, if the application comes to PIO and he is the most junior person, for example, sake of discussion, and he wants the information from the, say, commissioner or the drug controller, top drug controller, he can forward that application to that highest officer, and for that purpose, from that day, that officers become the deemed PIO. And if that information is not given, that officer is liable for action, including for any contravention. Information request should be in writing or through electronic means. Sometimes it is confused that some application is received through the email or some verbal application before me. So how I can give? There is no written application. This is not the case. Even electronic application. Therefore, all officers, I request that you designate one particular email for RTI purpose, and let us see that information. Then how to pay the fee? Fee can be paid in any format. And on your website, you can mention that fee of application or fee for the information can be paid on so and so this account. Application to PIO of the concerned public authority. Concerned public authority is the most important word here. Concerned authority, it is not a multiple authority. And APIO. No reason or personal detail of application is to be asked. Sometimes they ask, give the reason. No. Application transfer within 5 days. If it is concerned with the other public authority, it can then you transfer your application. There is every possibility that some parties with you and other parties with other application. Then what to do? I will discuss in later slide. If information is held by another public authority, then connected with function of another authority, it is available with you, but it is not connected with your function, then transfer application. Inform applicant immediately. In such cases, you have to inform immediately. Then we have a Maharashtra RTI rules, but this every state had the same rule because it is a central rule, as well as the central had directed that to frame the rule accordingly. So rules are same, though it is mentioned that Maharashtra RTI, all state same rule. Rule 3 of the say that to concern PIO, concern public authority, annexure in format A, but this is challenged in the many judgment that why annexure. I will give in a different format. It is okay. Then Information Commissioner had said that annexure is not a mandatory. In fact, it can come electronically, or illiterate person or some disabled person can give in a different format. 10 rupees fee for application, fee in any form. Then disposal of application. This is important section. How to dispose this application? Provide the information on payment of prescribed fee or reject application within 30 days. Information concerned with life and liberty of the person is 48 hours. So as soon as you receive the application, you should read the each corner of the application, all complete application, and see that whether applicant had mentioned somewhere that it is concerned with my life and liberty. Sometimes RTI activists very intentionally don't discuss this issue with you mischievously, and afterward they said that you have violated this provision. So read the application as soon as it is come in your hand. Reject the application based on section 8 and 9 provisions. If PIO fails to give a decision, it is considered as a deemed refusal. For further fee, send intimation with a detailed calculation. Sometimes many PIOs are not doing. They say that so and so pages information is there and you pay so and so charges. But it is not the case. You have to give the calculation. How many pages are there? How many A4 pages are there? Big pages are there? Then particulars of first appellate authority, because there is every possibility that based for fee calculation also citizen can go in appeal, and the time limit for the appeal. I have come across one case. One PIO had asked one citizen to pay 10 lakh rupees fee plus 10 lakh plus fee. He had calculated so much information. These are the pages. So much efforts he had taken and communicated that paid 10 lakh plus fee. But this is not the case. This is not required. How it is not required, I will come in the later. Then right of PIO to review amount. Even last week, I have come across this query from one of our officers that I have communicated wrongly that pay so much fee, and actually it is not like that. I have communicated extra fee to that person, and now he will ask more pages. But no issue. You have a very right to review your amount as well as remove the even form of access. You can deny the access that I cannot give the paper because that is a very delicate paper and I cannot take out the xerox, or vice versa. And you can inspect that, or if it is inspection is allowed, you can ask that you can come to the office and ask the relevant papers. Then period of intervention between the dispatch of the said information, fee letter, and the payment, that period is excluded from 30 days. And 35 days when application is to PIO. Then no fee from the BPL or BPL person as proof. But here this provision is also misused by many BPLs. So you are not supposed to give huge information at free of cost. There are a judgment because you are not supposed to spend the fiscal resources of the government offices. If PIO or PA fails to comply with the time limit, provide information free of cost. Sometimes some or other reasons, time it's 4 days delays are there, and then you have to give the free of cost information. Here, sometimes it is miscalculated that there was a Saturday, Sunday, and or some 3-4 holiday came into picture. Therefore, this has happened. So some activist or some applicant, I will say, they are very genuine. They say that no issue, but then give information free of cost, and that provision is there. Then consider representation of third party under section 11. This is the most important provision, which is not many officers are not implementing. Any information concerned with the third party, all applications received from the, whether it is sale, whether it is the distribution or manufacturing, is the third party information available with us. So this section 11 has to be implemented very scrupulously. If third party if a request of the third party is rejected, PIO shall communicate these reasons. You have to, after receiving the information, if you find that this information is concerned with the third party, this is not a government document, though it is in the custody of the, under control of the government. This is not a MIAB document, this is third party document. Immediately communicate to that person, I have received this application, and see, language should be like this. We would like to disclose. Let burden be on law. We would like to disclose this information. Kindly communicate your this thing, objection or whatever it may be. Then if request is received or if information is received, then communicate this to applicant, the reason of such rejection, appeal period, particular of the appellate authority, and 30-day time is again here given here. Again, this is also misunderstood many times, because 30-day time is already over. 30-day time is over earlier time. But if this provision came into the picture, you can give another 30-day time for the appeal to any party for that purpose. Citizen applicant can go in appeal within 38 days, or the person, if you have decided to give the information, don't give, don't decide immediately that I want to give and give the information. No, let that person go into appeal. So you have to write this letter categorically and give the appeal period. Provide information in requested form. This is also misconstrued by the many citizens. Requested form means if it is asked in the paper document, and if it is asked in the floppy or pen drive, in that form. The form means they design some form and they give. This is not the case. The huge information, another issue is all the officers are facing huge information. If disproportionately divert the resources, or which is detrimental to the safety or preservation of the record, infirm inability, public interest shall be visible in this letter. I have prepared some draft letter to our officers. Generally, even weekly 1 or 2 times, I used to send this on WhatsApp to all. Here, your preamble should be there, referred in that document. And another thing is, information is so huge that whole my office will have to work on that office, and how I will work, or my office will work for public cause. So therefore, though information is asked, we are unable to give because of in the larger public interest. You have to mention this. In the larger public interest, I cannot provide this information as per the section 7(9) because it is disproportionately diverting resources and ultimately leading to the larger public interest and hampering the public work. You have to mention like this in that letter, then there will not be any problem. Then again, in Maharashtra, fee is everywhere same fee, plus postal charges you can ask from the citizen. Actual cost, A4, A3, A4 size paper, 2 rupees cost. If it is a bigger size paper, 5 rupees, bigger size paper actual cost. And if it is floppy disk, it is 50 rupees. Mode of payment is again many times disputed. Mode of payment, there is no binding. Citizen can or applicant can pay the fee in any form to the account officer. Another thing is concerned public authority. I have mentioned in the earlier slide. What is meant by concerned public authority? Here, Government of India, there is one circular. If part information is available with the public authority, and the rest of the information is scattered with more than one public authority, then what to do? Give information relating to your office and advise the applicant to make a separate application to all other concerned public authority. Some applicant very categorically say, it is your duty to send application to all offices. No, you have to refer this judgment. You can share this my presentation as well as some guidelines are there. These guidelines can be downloaded from this central government site. If no part of the information is available with you, but scattered with more than one other public authority, then make separate application to all other concerned offices. You are not supposed to transfer application to more than one office. If it is one office, okay, you can transfer. That too, if you are authoritatively and knowing that information is concerned with that public authority, or it is a part of function of that public authority, then you transfer that application. Then PIO is not supposed to create information, interpret information, solve the problem raised by the applicant, reply hypothetical questions. Sometimes citizen asks that yes or no answer, or give this answer. You are not supposed to do it. Document in section 3 say that what is held, what is exist in the office. So you are not supposed to answer and query. Supply only such information which is already exists. Sometimes this is also misunderstood, because so and so dealer is in your jurisdiction, and so ask information from them and give me. No, is it already available, and is it exempted from the other provisions? That you have to see. Supply information in available form. Lengthy information, these are some important judgment. Lengthy information, intention seems to be designed only to put the public authority under undue uncalled for pressure. This is a mockery of the law. This is what the Central Information Commission, this is a landmark judgment of the IIT Delhi and Central Information Commission. Deemed PIO faulty. If the application, you forward application to your office concerned that give the information, and if you don't give, he is liable for action because he is a deemed PIO. Call such person for hearing before commission. Commission can ask, call that person who had not given. There are so many judgment on this. Information rejection letter must be speaking. Then exemption under section 8 and 9. This is the most important, in fact, heart of the this whole law as far as the regulator is concerned or public authority is concerned. Many applicant or citizen challenges this, that how you can deny information, or this is our constitutional right. No, it's not a constitutional. Article 19(1) of the Constitution categorically speak that central government or government can frame any law and give any restriction, reasonable restriction, and accordingly Right to Information Act and this section 8 and 9 is included in this act. Article 21 is another important provision, protection of personal right and personal liberty. This is most important. So backbone to section 8 and 9, sometimes it is challenged. This is the backbone. So our officer should know these things, and so that he will be confident that if some matter goes to the High Court also, this provision will be a most important provision to quote. Then some other judgment, no obligation to give any citizen information regarding section 8. This is section 8. Sovereignty, integrity of India, security, strategic and scientific information. Scientific information, because we receive the scientific information in our office. Flow sheet of the API, for example. Economic interest of the state relating with the foreign country. And another is the information, if I disclose it, which will lead to incitement of the offense, any offense, don't give this information. Information forbidden at the court, breach of privilege of parliament and state. Then another, this important information, commercial trade secret, intellectual property right, unless the competent authority is satisfied, larger public interest. Here, competent authority is not the government. Either competent authority, as far as the state is concerned, is the governor and High Court, Chief Justice of the High Court. So you have to say that go to even Information Commission is not there. In some time, Information Commissioner had order this, that give information. This is wrong. You can go in appeal, or you can go approach to the governor or High Court that I am not supposed to give information under this thing. Another important thing which I would like to ask you, draft letter in such a fashion that burden should not be on PIO. Burden should be on law. You say your drafting should be such that as per so and so provisions, I am unable to give you information because this so and so provision, I cannot give the information. So here that person has to prove the law or challenge the law. And if you say that, no, information cannot be given to you, one letter, then you have to prove it. So your letter should be drafted in such a fashion. Then information available with the public authority in fiduciary relationship. Our relationship with the all dealer, all industry is a fiduciary relationship. Here also competent authority is required to be satisfied and the larger public interest is required to be satisfied. Information received in confidence from the foreign government. Then this is another important provision for which endanger the life of and physical safety of the person or identity of the source of information. Sometimes many applicant come that who had given information to your office. Give me that complaint copy. Many applications are coming. You are not required to or supposed to disclose this information. Even court is not asking. Even the parliament or even any MP, MLA cannot ask you that who had given the information. So this is this provision you have to apply. And here also you write that as per the so and so provision, I cannot disclose this information to you. Another important is impede the process of investigation, apprehension or prosecution of the offender. Here also, even I very boldly I will say that some information commissioner, especially state information commissioner, had given a wrong judgment on prosecution because that is not challenged. Therefore, it is a binding. It becomes the binding on the officers. But some or other time they can be challenged. Investigation is in the part process, and they say that give the information which is not supposed to give. Our prosecution is in pending in the court. How to give the who had given the statement and who are the witnesses? Your witnesses? No. Then sometime the information commissioner also not. And unfortunately, some information commissioner appointed where the activist itself. So this very boldly I am saying this. Cabinet papers, record, deliberation of the council of ministers, secretary. Okay, this is not concerned with us. Then personal information. This is again important provisions. Personal undue invasion of the privacy of the individual. No relationship to public authority. Even in the recent judgment of the Supreme Court in Aadhaar case. No Aadhaar card can be disclosed to any person. So our constitution under Article 21 had given a protection that our personal information cannot be disclosed even to the any person. Even sometime court cannot ask this information unless and until the larger public interest is revealed. PIO or appellate authority justify the disclosure of such information. Here again, I will just take you back to competent authority. Then information which cannot be denied to parliament or state legislation cannot be denied. Here, this provision is also misconstrued by many applicants. They say that if the your MP or MLA come to office and if he asks that give me this information, even you cannot give the personal information to MP or MLA. We show everything, but officially, even in the law, when we draft the complaint, we say that based on anonymous complaint. So all this personal information cannot be disclosed. Under Article 21 is the backbone. If public interest outweighed the harm to the protected interest, public authority or PIO shall allow the access of information. This is the most guiding principle. What is the public interest? PIO has to think on this very silently. What is the public interest? Sometimes, in fact, weekly 1 or 2 phone call come to me that they ask that the so and so person had asked that rent agreement of so and so medical store or so and so company or what lease agreement. What is the public interest? That document or that agreement is between two parties. So how public is affected? So that document is not required to be accessed or given to the public. Here, no bar to Official Secret Act. Official Secret Act is not completely repealed. Then 20-year-old information, Section 8 exemption, no bar intimations. This is another provision. 20-year-old information is required to be disclosed, except which can lead to an incitement on office and personal information. Sovereignty of country, strategic, scientific importance. These are all, even after 20 years, you are not supposed to disclose such information. Dispute of 20 years, who will calculate this, solve the dispute? Central government. Here, state government had not given any authority to solve the dispute. If somebody is disputing with you, you say that 20 years is not over, and another thing is this information is also again after 20 years also under exemption, and go to central government. Then ground for rejection. Then another section is Section 9 is of course a copyright and right to information. Here, this person, the copyright subsisting in person other than the state. This is a very important provision. If some copyright is taken by the state, this is not applicable to the applicant can ask the copyright of the state also. But in my opinion, actually this should, because sometimes there is, of course, there are some other provisions, strategic information under Section 8(1)(a). So under that, the state can reject such this thing application. But as far as the personal copyrights of industry copyright cannot be given, sometimes we ask the information of, for example, flow sheet, API manufacturing, flow sheet, and all these things document. So this is a absolute exemption. Here there is no even scope to competent authority as well as PIO and even in the court that you disclose the information. Strategic confidential document, if possibility of misuse against public interest cannot be disclosed. IT return is a confidential information of third party in a fiduciary capacity. It is a confidential document not to disclose. This is the most important landmark judgment. Every officer should download the GR Deshpande versus CIC. Copy of memo, show cause notice, order of punishment, performance of employee in a matter between employee and the employer. And this is personal information. IT return is also personal information. Some applicants say that how the show cause notice or some punishment given to a particular office is a personal information. It's larger public interest. No, it is not the larger public. Sometimes some happens because of ignorantly or some in this way. So there is a very possibility that the information may be misused for tarnishing the image of our employee. So therefore, this is a rule by Supreme Court. So you can very well quote this. Visitor register of the police officer denied. Where if state have IB intelligence bureau in the state, you can deny that register. Then complaint under inquiry document is exempted. If anything is under inquiry, part-heard matter, don't give that matter because there is every possibility of the misuse or helping or against to that matter. And investigation, what is meant by that? Investigation is word used in the one section 8(1)(j). What is meant by investigation? That word investigation includes criminal as well as departmental inquiry. Just generally it is misconstrued. Departmental inquiry is not an investigation. So investigation should be taken completed when the competent authority make the decision. Sometime initial inquiry is completed and then they say that now give information. No. The term investigation would include inquiry, search, scrutiny of the paper. Either it is a departmental or criminal. Therefore, DE is a personal information and cannot be denied and can be denied. It cannot be given in a middle part heard matter. Statement of the CBI fiduciary capacity, matter is before court, don't give. Even in the Maharashtra, I have come across many cases that the whole judgment, whole complaint copy is given to the applicant, including the list of the witnesses. How you can give the witnesses? There is every possibility that it can be misused in a pros and cons way, either to help that person or to unnecessarily harass that person. So that cannot be given. Disease, financial status, income liabilities should not be given unless public interest is revealed out to it. Here, there was one judgment in the Maharashtra. One high-profile person was convicted, and he stayed in the hospital. At that time, that one RT activist say that he is not actually ill person, and he asked the medical record. That time, information commissioner had given but actually at that time, I am of the opinion the person should have gone in the High Court and he could have succeeded under the Article 21 of the Constitution. Personal information of own can be asked at any time. That is true. Third party information cannot be. Our own CR can be asked. Our personal information can be asked at any time. Personal information such as service details, family details, etc. cannot be disclosed to third person. Third party information procedure section 11 should be followed. Because it is section 11 is the third party notice, except overwhelming public interest is there. Proceeding for prosecution against the person is under process in the court of law. As such, disclosure of the information would impede the process of prosecution, so it is exempted. So my request to all officers that don't give complaint copy also. Even if you observe that if someone is want to intervene in any matter, court take the first application. They discuss that application. What is your role here? How you are concerned with this information? And then court order the intervention application. So here, how court information of the prosecution whole file can be given? It is given by the some officer, but I request that don't give this information. Law is with you. In fact, law is expected to do this. Then severability. Sometimes it happens that some information is can be given, disclosed, and some information cannot be disclosed. Even 4 days back, one officer called me that part information, for example, license copy. License copy is a public document. We display it in the shop, in the front, so that it will be visible to all. So I say that you can give, but other rent agreement and all these things you don't give them. Only part information can be provided, but you have to give the speaking letter to that application that why I have taken this decision, and including the provision of appeals. Then third party information, confidentially treated information of third party, give notice within 5 days. So as soon as you receive the application within 5 days, you should communicate to the third party that your information is asked by so and so applicant. Disclose that name of the person, nothing wrong in it. And if nothing is received, your reply is not received, we will give. Then you are free. Then except trade and commercial secret, disclose allowed information. If public except trade or commercial secret, disclose allowed if the public or third party interest outweigh it. Only larger public interest is revealed, then we have to reveal. So general information of the rent agreement and all documents cannot be given. PIO within 40 days. Here 10 days are given. If third party is intimated, you have to give the 10-day time to the third party. Just so PIO within 40 days. Now here why 40 days? Because 10 days time is given to the third party to reply, and within 40 days you have to communicate to the third party and your decision has to be communicated that I have decided, I have accepted their submission, and you can annex that submission, what is submitted before you. And because of that, I have come to the conclusion that I am giving this information, I am denying this information or giving in either case, your letter should be speaking to both party and they both party can go in appeal. If you decide that giving the information, then the person whose information is there, he can go in appeal, or vice versa. So appeal period is again 30 days. So how much time now here? Earlier 30 days is given by statute. If it is given by to APIO, 35 days. If the third party application is communicated 10 days, and again here 30 days. So about 70 days you will get the time. So 30 days, don't get confused that 30-day time is given. So this is a 70-day time is there. Section 11 is mandatory and substantive provisions. Many PIO is not following this thing. This is a very, very wrong, and it is a violation of law. IT return and related document is a personal information, cannot be disclosed third party unless there is overriding public interest. See, this is the most important judgment of the High Court, and see the High Court in which language they observe. It is kept in the mind by all the PIO, first appellate authority, as well as the second appellate authority, that is Information Commissioner. Any information relating to third party or supplied by the third party or has been treated as a confidential by third party, always follow procedure as laid down under section 7.7 and 11. You have to communicate and take the consent of that third party. Then another provision is, there is one provision in under section 18, complaint to Information Commissioner has two powers under section 18 and under section 19. Under section 18, there is a complaint provision, and under section 19, there is appeal provision. So why these two provisions are there? Initially, I was also confused. Why these two provisions? And there is a repetition. But this is a supervisory authority. So Information Commissioner had given a supervisory role here under this section 18. Ground for complaint is public authority had not appointed PIO, EPIO, sometimes because of the transfer or some other reason, refusal of or accept application, and refusal of information requested, no response to information, unreasonable fee, like I have explained, 10 lakh fee was asked, incomplete and misleading false information, any other. Then inquiry here, commission has a inquiry power as civil court. Commission can discover and inspect and examine any record of public authority. This is a big authority or given to the Public Information Commission. Commission can visit your office and they can check that whether you are correct or wrong or misleading. So they can visit. I have not seen so far any Information Commissioner visited office and examined the record. No such record may be withheld from on any ground. So this is a supervisory role of the Information Commission. And this is another section 19 is a first appellate authority. First appellate authority shall be senior officer in the PIO office. Generally, this senior word is sometimes office sometimes overlooked, but the person should be senior in that office for first appellate authority. Ground and time limit for the first appeal is 30 days. Does not receive why appeal can be filed, does not receive the decision within the time frame agreed by the decision, and concerned third party also can file the appeal. Even here, public office, our office can file the appeal before the PIO. For example, Commissioner of the FDA or the Drug Control of FDA, PIO had given application to Commissioner of Drug Control that so and so information is asked, and that is lying with you, give me. And if he don't want to give, he can file the he can be a aggrieved party and he can file the appeal in the first appeal before first appellate authority. So a law is very nicely drafted, but it is misunderstood or intentionally misconstrued by many applicants. Delay condonation provision is there like every law. First appeal disposal 30 days and in exceptional case 45 days. Second appeal lies before the State Information Commission or Central Information Commission. 90-day period is given. Same ground, if does not receive information within time, agreed with information, concerned third party, again here all third party as explained can go to the appeal. Here again, for example, third party information is rejected, then first appellate authority can give decision. Even first appellate authority say that no, give information. No, third party, you have to again wait. PIO is not supposed to give information immediately because first appellate authority, who is a senior in that office, gave the decision. It is happening in the in case of many PIO. Don't give. Let us give that opportunity to go to the appeal to the third party. 30-day time is there. So don't come under pressure. Delay condonation if sufficient cause is revealed. Opportunity to heard of the PIO and deemed PIO and third party. The Information Commission cannot take decision suo motu. They have to give the opportunity. Onus of denial of information is of course lies with the PIO and deemed PIO. The decision of CIC and SIC shall be binding. Though this statement is there, shall be binding is misconstrued and misunderstood. There is a writ provision also available. CIC, power of the Information Commissioner, secure compliance of that, can give the directive to any officer for compliance of that, provide access to particular form, appoint PIO, publish certain information. This is important provision, change practices of maintenance and management or destruction of the record. Some office may have a bidding policy, faulty bidding policy. The PIO Information Commission can say that this is your fault, wrong destruction policy. So revise it. Train all officials, submit annual report, compensate the complainant. Sometimes the Information Commission can order you that compensate completely because of so and so loss happened because of you have not provided information in time. So office has to compensate. Here compensate the complainant here, not the PIO, by the office. Then office can initiate DA, that is separate issue. Impose any penalty on the and reject the application. Then CIC and SIC shall inform its decision, including any right to appeal. Here earlier statement there was, this is the judgment is final. And here CIC, even Information Commissioner has to say that you have a right to go in appeal by way of writ petition. Though in the provision, section 19, it is said that decision is binding. So decision is not binding. It is a constitutional right given us to go in the writ. CIC and SIC decide the appeal in accordance with the prescribed procedure. First appeal, again, a rule is same provisions are there. 20 rupees fee, 30-day time for appeal, delay condonation provision is there. In the case of second appeal, 90-day period is there, otherwise 20 rupees fine and all other provisions is there. Power of Information Commissioner for penalty, ground for penalty to PIO and deemed PIO. Deemed PIO can be punished if PIO prove that I have forwarded application to deemed concerned person within 5 days. Then after 5 or 10 days, you remind that your office, though he or she is in from your office, remind it by in written communication that this time limit is over. Now give information telling you there is every possibility of penalties and all these things you mentioned in that letter. And if at all it is not given, then deemed PIO is liable for fine. It is misunderstood that only PIO is fine without any reasonable cause and mala-fide intention. Here there is some provision kept for the PIO for rescue. Reasonable cause, if you are able to prove the reasonable cause, because sometimes it happens, because say in the lockdown period, this is the reasonable cause. You are not able to give, or so many reasons are there. Refuse, very intentionally you have refused application, not furnished information within a time limit, denied the request, then knowingly gave incorrect information and misleading information. Knowingly, this word is important, knowingly. Yes, I don't know, this document is available because see, information, you are supposed to give the information what is held, what is exist in the office. You are not supposed to manipulate, I mean, you design information. So in this case, you have given that paper. So what is content in the paper, your PIO is not responsible. So here there is a rescue to the PIO. Destroyed information, if it is information is destroyed, punishment can be given. Obstruction in furnishing information, PIO or deemed PIO, and can be punished. Penalty, what is penalty? Penalty for PIO or deemed PIO after a reasonable opportunity to prove due diligence. Due diligence is I have communicated on and upon to my officers that due information, time limit is there, 30 days there, so and so. So this is the due diligence. Then 250 rupees per day till information is given. Maximum 25,000 rupees fine can be done. But if it is undue or if it is justified, Information Commission can request to your office for disciplinary action or departmental inquiry. These are other provisions. The Section 21 is a protection of action and in good faith. Generally, it is available in every act and every officer is aware of. Therefore, I have not much stress upon it. Act to have overriding effect. Overriding effect here, overriding word is given, not repeal provision is there. So, Official Secret Act is not repealed. Bar of jurisdiction of the court. You cannot go to the court. Sometimes some applicant, especially blackmailers, I will say very boldly, I am saying blackmailer. They say that I will take you into the court. So they cannot go into court against the PIO. They have to follow the channel of appeal. Act not applied to certain organization. Now 22 organization in Schedule 2 are there. The CBI and Enforcement Directorate and all other offices, monitoring and reporting, appropriate government prepare programs, rule making powers, and all these are there. So not much useful to our officers. Therefore, it is summarized. CIC cannot appoint inquiry committee. This has happened in some cases that Information Commissioner had appointed an inquiry committee. So CIC has no any authority. It is not a court. It and cannot exercise plenary jurisdiction. If the order is appeal is not followed, what to do? Complaint is the option given. Complaint, even PIO can complain. Review may lie against the cases of commission. Commission sometimes because of the lack of information or some information is not submitted in timely and judgment is given before that. So you can again apply to PIO, Information Commission, that these are the documents which are available. Will you please review this matter? Review petition can be filed. Appellate authority can be penalized. Disciplinary action can be taken under the service rule. This is also important because sometimes appellate authority in the office, they say that only PIO punishment provision is given to PIO, 250 rupees and disciplinary action. No, it's not the case. If appellate authority is not applying the mind, then disciplinary action can be started against them. Another thing, as far as the appellate authority is concerned, I observed that they're so afraid to the activists and they say that give information. So this is also not wrong because third party may sue to you in court. So appellate authority should be also vigilant and in compliance with the law. Gujarat High Court had given a directive to even Information Commissioner. Don't violate the right of the third party. Department compensate application. Here compensation, who to give up department? Section 8 is supervisory, section 19 is appellate authority. Aggrieved person could be PIO, third party or public authority. VAT return, income tax return, etc. is the personal information. And here in one judgment, one opponent was asking the VAT application and all other information. Court had fined 75,000 to that person, Delhi High Court. Then, as far as this act is concerned, special law versus this general law, this is too much confusion among the many applicant as well as in the many PIOs, which supersedes. If general laws are there, even before 2005 there are many general laws. Even after 2005 there are many general laws. So which supersedes? So there is a misconception that RTI Act supersedes every act. It is not the case. General principle of the law is earlier act must give place to later act. But if this principle is there, it is a Latin principle, general lex posteriori derogati priori. If the general law derogate the special law, then this provision is not applicable. But if in the general law, there is a specific provision of repeal of the special law, then that will supersede. In other cases, that will not repeal. Even RTI Act is a general law of 2005. Drugs and Cosmetic Act is very old act, but RTI Act will not supersede our any law as far as FDA or Drug Control Administration is concerned, because in RTI Act, I have not find anywhere that any repealing provision or superseditory provision in the RTI Act as far as these other acts. Same is the case with the Income Tax Act, VAT Act and other laws. So this is a Supreme Court judgment, very landmark judgment, very, very nice judgment. RTI Act does not repeal, substitute pre-existing special law, including IT Act, special law provision supersedes general law. Therefore, Section 138 of the IT Act supersedes the RTI Act. So, Jai Hind, thank you.
Oh, thank you so much, sir. That was a really elaborative and in detail presentation, and I'm sure that all the participants have thoroughly enjoyed the minute aspects of this act and the procedural formalities to be followed, and especially special thanks for the detailed judgments and clear explanation of everything, sir. Really appreciate your time and efforts in making the presentation so in detail to the participants. Thank you so much, sir.
Thank you. Thank you.
And I request all the participants to kindly post your questions in Q&A so that we'll take up one by one and only from 1 to points in the Q&A. Alternatively, if anybody is willing to have the questions with a detailed explanation, probably you may also raise the hand. And but in view of the elapsed time, we may not be able to accommodate many of the participants. And before that, we would like to recognize the presence of Shri Manmohan Taneja ji, Drugs Controller for FDA Haryana. And I could, we are so glad to have you, sir. I think you have been in the program the entire 1.5 hours, and you have been actively listening to this program. We really honored to have you for this program. So quickly, I'll be taking the Q&A, sir. Sir, would you like to close the presentation, sir? Share screen slides.
Just a minute. I am trying to close the presentation. Can you close from your end?
Just let me.
Okay.
All right, it stands. There are a few questions I could see in the chat. One is from Dr. Jakshegi. Can the status of an investigation can be given to the applicant? This question is if an applicant, RTI applicant requests for the status of the investigation be given to that applicant under RTI Act.
Because see, status of application, if that is a complainant, you can very well give to the complainant, but no document. Okay, it is under process.
So the investigation status also can be given to the applicant. Right?
Yeah, it is under process only to the complainant, because complainant has every right to ask what is the status of my complaint, but no any other paper, no document.
Sir, in case if the RTI applicant is not the complainant, but some other third party request for such information,
no, nothing to disclose.
And another question from the Dr. Jaksheti again is that whether the APRs and ACRs can be disclosed, whether the annual confidential reports and the annual property reports can be disclosed. I believe. I'm presuming it is not to be disclosed. Will you may please?
Yeah. That is also already covered with, supported by many judgments also.
Exactly.
Sir, another question is employee attendance sheet in the government offices, whether it is a third party information or not.
That is not a, it's a office information. So office is also third party.
So this employee attendance sheet can
The
consider
employee attendance is all, it's not a single person's document. It is an office document. So it is a third party document.
Okay.
So whether it can be shared or not.
Now, third party information, that a document definitely can be shared because that is not a confidential document. Because
Okay, sir.
only document which is for example visitor registers, especially to the inquiry officers, that is a confidential, because the who visited there to for giving information and all these things.
Sir, another question from Mr. Ram. That can PIO provide a copy of Shoka's notice or the suspension or cancellation order issued to firm? And can the PIO provide copy of the reply submitted by the firm in response to the Shoka's notice?
No, at the initial stage, no, because see, initially there is every right of that person to go in the appeal, and the final authority, competent authority, had decided that matter. What law is said, before that there is every possibility of misuse. I have been served the Shoka, medical store have been served the notice, the reply is received, and suspension order is given. Okay, and then appeal we lies before the minister. So final decision is not there. So we are well aware of the in today's scenario how much people are pursuing for the or either way. So impaired section, there is one provision, impaired in the process of investigation and prosecution or apprehension. So it is an impediment.
Uday sir has some questions. Sir, please.
Salimkeji, the presentation is great, even after it's almost 1 hour 40 minutes.
Oh,
but everybody
you.
is stick on to the their Zoom, and it's one of the fantastic sessions. I have one question.
Yes.
The very recent controversy is PM Cares. PM Cares, the Delhi High Court said that government has submitted an information that PM Cares we cannot disclose under Right to Information Act. Prime Minister is a public servant.
Right.
And the people are giving money for PM Cares because he is a Prime Minister. We are not giving money to Mr. Narendra Modi.
Right.
In this case, what is your opinion?
Now, PMK is a public fund. PMK is a public fund, so nothing wrong in it disclosing it, because they are getting the exemption also under even IT Act and all these things. There are some political compulsions.
So compulsions are not to the lower level and inspectors the government officers.
But as far as our rule is concerned, or it's a exchequer of the government, though it is a PMK or whatever it may be, it is exchequer of the government or public, and government means public. Therefore, budget is published in the book now.
Thank you.
Thank you, sir. So quickly, I will take a couple of questions after we are running ahead of time. May I take a couple of questions, sir? Sir, of course.
Yeah, I don't have an issue.
Okay, thank you, sir. Sir, when the licenses and the registration, I mean, these days, all the processes have made online, and when the information is issued online, like the licenses and the registration data. So in such cases, how can these information can be given under RTI?
Right. See, if the information, right to information, that definition is seen, the document exists and held, that word is there. If physically available is, but there is one word, information covers the inspection and copying also, or printing the information available in the computer. So that wording is there. So if it is available on your this thing website and all, you can very well give or software.
So the soft copy of the information downloaded from the website certified by the concerned office can be given and updated, right?
Yes, yes, yes.
Okay, thank you, sir. Sir, and the final question from one of the officers is that can the service book records of an ex-employee is asked under RTA, can it be given?
No, service book is absolutely a confidential document.
So even under RTA, the service records of employees are not allowed to be.
Thumb rule is that you have to you have to think that if I don't give, what is the impact on the larger public? How larger public is going to affect if I don't give the service book? No issue, because that person, particular person who is asking, has some vested interest or rivalry interest.
That's a bottom line. Now we need to look at the importance of the document that they have requested for the benefit of the public or for the society, not in terms of the personal interest.
Yes.
Thank you so much, sir, for the final conclusion. And may I request our President, Dr. Jayanta Chaudhary ji, for the concluding remarks for this.
Thanks you, Lakshmi. Lakshmi, can you hear me?
Yes, sir.
Yeah, you are audible.
So I am extremely happy to be present with this important webinar today. Overview of Right to Information Act, public authorities, regulatory perspective, and personally gain knowledge about the subject from Mr. S.R. Salunke, former Assistant Commissioner, FDA Maharashtra. He nicely explained various provisions of the RTI and is a very valuable deliberation. Nice introductory remarks about the topic by Mr. Uday Bhaskar, sir, Director General of All India Drugs Control Officers Confederation. So what we learned from the deliberation that the Right to Information Act, history, different related judgment, dissemination of information, public authority, third party, etc. etc. So it is important to have a clear knowledge of the provisions of the Act to the public information officers, shortly known as PIO, is key to the successful implementation of the Act, and that would further enhance our understanding of the provisions of the Act by both the information seeker and the information providers. So this deliberation would go a long way in further and strengthening of the RTI regime. To make it more simpler, the public authorities, including our regulatory authorities, are also under the public scanner. Any citizen may ask any kind of information, so far about the quality of drugs, notification, administrative measures, samples, surveillance, license, everything. But PIO has to answer all this information. He has to give information carefully with regards to the provisions of the Act, particularly the larger public interest. We also learned a lot from Mr. Salunke, the quality and quantum of informations by the public authorities to be get uploaded on proactive basis in the for the public domain, and get the also to get the proactive disclosure audited frequent. So also Salunke also explained that the suo motu disclosure is a valuable component of this RTI Act, and large amount of information should be in the public domain on a proactive basis to reduce the need for filing individual RTI application. This is very important. We have to reduce the application. So proactive basis, a suo motu disclosure of information is the must, is to be followed by the all PIO. Friends, today we live in a knowledge era where consumerism, awareness, rights, and claims are the order of the day. Undoubtedly, RTI Act has helped to raise civil and unheard voices of the Indian citizen and to protect their interest in keeping track of the government work. Shalukya sir also explained, it has created a sense of responsibility not only to the officials but also to the people also. On the other hand, it definitely encouraged the participating democracy in Indian context. So last but not the least, such a webinar definitely enrich our knowledge base in dealing RTI matters. Requesting Shalukya ji is for such type of lecture in future also. Your deliberation has come a long way and clear our doubts and misinterpretation to a great extent. Once again, I express my gratitude, sincere gratitude to Mr. S.R. Shalukya ji for his immensely valuable and nice deliberation on the topic. We also thank our CC members, Executive Council members, senior distinguished regulators, industry friends, colleagues, and all other regulators who have attended to this webinar. Thank you one and all. Thank you, sir.
Thank you so much, sir. That was an elaborate, detailed concluding remarks, and you have made my job simple also, extending the gratitude.
In the recent past, sitting for almost 2 hours very interestingly is a very rare phenomenon. Really, we learned so much from Shalukya ji. I think, Jayanta, we need to take up this session, whenever we are organizing zonal-wise the training. So now the almost third wave is also gone. So we can go for a physical training to our officers in the journal. This is very much relevant and important actually.
Okay.
Thank you, Shalukya ji. Thank you so much.
Thank you. Uday ji, you can order me at any time. Thank you. Thank you, Lakshmi.
Thank you so
all
much.
delegates.
Thank you, sir.
Thank you so much, sir, and thanks everyone for the patient listening, and stay tuned to our updates. We'll be sharing the link and the presentation.
You can share that PDF format which I have sent.
Definitely, sir. So the presentation will be shared to all the participants by
Yeah.
Thank you so much, sir, and have a good day.